This has been, maybe some people would say, I think it's been relatively, it was a short, seems like a short trial, and now the jury has it midweek, started on Monday.
Well, you know, the shortness or the brevity of it was almost expected by some of the criminal defense attorneys in this case, or anybody who was familiar with this case, because it was highly circumstantial. We didn't have DNA, we didn't have a body. Those are the types of things that take a lot of time up in the court. And also, they spent a lot of time on technology and witnesses that, for lack of a better word, jurors just need to hear what your specialty is and what you're here to prove, and then move on. But there was a lot of kind of dwelling on the camera and the cell phone and things like that. So the brevity of the case did not surprise me at all. Now, the most important thing for the public to know is that not putting up a case, meaning the defense called 0 witnesses, is a very good strategic, tactical advantage for a criminal defense lawyer. Why? Because that means you get what's called last close. You get to be the last word to the jury. You're the last thing that they hear, which is extremely important. Because in this case, I think the most emotional witness, probably the best witness for the state, was the roommate at the end. She humanized Heather. She brought it back. To this was a human being. She had feelings. We talked. We had wine nights. You know, that type of thing. Instead of just, this is a girl who's texting and was interrupting a marriage, if you will. And so if Mr. Truslow would have called a witness, he would have let the state have that final witness to say, and then the state would have been able to say, this is our last argument. We're going to be the last ones to talk to you before you go back and deliberate. And that's another thing about the deliberations. It's starting at 5 o'clock on Thursday. These jurors are exhausted. The judge even cut short the state's closing argument because I really do think that they're ready to just kind of make their decision. But one night, I think they'll sleep on it, and I think we'll have a verdict sometime mid-afternoon tomorrow.
And one of the things we have talked with you about in the past is the gag order in this case, and your concerns about that.
Well, as a First Amendment advocate and a First Amendment lawyer, I certainly there are concerns when there's a gag order in place in any case. I mean, I have cases against police officers. I have lawsuits against the actual prosecutors in this county, and we don't have gag orders in place because it's important for the public to know what's going on. That's what the courthouse is for. Everything filed is public and whatnot. And you got to remember, the state asked for the gag order in this case, not the defense. That is highly unusual. It's usually the defense pounding and saying, we don't want anything coming out. There's just too much evidence, and it could be played in the media the wrong way. We need a gag order in this. But the state went forward with a gag order. From the very beginning, it bothered me for one reason and one reason alone. The state is us, and we need to know what's going on in our judicial system, who we're trusting with it. And 2.5 years later, we're seeing what we weren't being told. And had we have seen this a year ago, I think we'd have been calling for either more investigation or at least at the very minimum, I think we'd have been calling for the charges to all be dismissed, and then we'll take this up at a later time. Because once the jury comes back tomorrow, or whenever they come back, if it is a hung jury, which many people believe at this point, or if it is a not guilty, the dominoes fall. And you can't try Tammy, in my opinion, for kidnapping, right? In this case, they pointed at the empty chair, being Tammy, the wife. Oh, well, she was the one with the phone. She was the one sending threatening messages. Empty chair. Well, now how are you going to try Tammy? And then he'll have another empty chair. It'll be Sidney, the guy who had the affair. So, this will have lasting effects on not only the murder trial, but also on what will happen with Tammy.
Well, we'll keep an eye on it as the jury deliberates.
Yes. All right, Jonny McCoy, thanks so much for being with us.
Thank you.
The Heather Elvis trial that happened this past week, this was Sidney Moore on trial, one of 2 people charged with kidnapping in this case. Jonny McCoy joins us now. Everybody, I think, who has been following what's happened here, let's say it was a tragedy, this 20-year-old girl has been missing since December 2013.
2.5 years.
2.5 years, and not too long after the disappearance, I'd say within about 3 months, Sidney and Tammy Moore were arrested. They were originally charged with murder. The murder charges were dropped. Kidnapping and some other charges remain.
Right.
This past week, Sidney Moore was the first to go on trial, facing just the kidnapping charge in this case. Now, I have to be right up front with people. We taped this show at 3 p.m. on Friday afternoon. I was thinking possibly a verdict could be in by 3 p.m. Friday afternoon, but the opposite happened. The jury came back, told the judge that they were deadlocked. The judge gave them what's called an Allen order, told them to go back keep deliberating, you took an oath, and you're the best qualified people to decide this case. That's where we are now.
That's where we are.
Are you surprised?
Not at all. In highly emotional cases, jurors are sitting back there, and if they're deadlocked, and I believe the overwhelming feeling right now is that they're deadlocked and it's pretty close to not guilty. There's probably 1 or 2 holdouts for guilty. And what I mean by holdouts for guilty is you've probably got 1 or 2 people back there who are saying, I just can't live with our judicial system saying guilty people can get let free because this reasonable doubt, this burden. He did it, but there just wasn't enough proof. Just doesn't sit well with a whole lot of people in the jury room. And that's probably what you're dealing with right now. And you've probably got 8 to 9 people saying, look, we're exhausted, we've been going through this, there's just not enough evidence, we're not moving. There's a whole group of us, there's 1 or 2, 3, 4 of you. Let's hear out exactly what it is that you think proves beyond a reasonable doubt that makes you firmly convinced without hesitation that this guy, for the rest of your life, you can live with the fact that you came down with a guilty verdict on a kidnapping charge where somebody's facing 30 years in prison. Allen charges are common in these emotional cases, and I'm not going to say I predicted one, but I definitely said that it would be a hung jury or a not guilty after the state closed and the defense didn't have to put up any evidence. And I say didn't have to put up any evidence because here we are. They're deadlocked and they didn't call a single witness.
Now, since we don't know the verdict as we tape this, let's talk a little bit about the trial itself, which started on Monday. Jury selection happened Monday. Opening arguments started Monday. To me, it seems like this was a pretty fast-moving trial. The prosecution made their case over about 3 days. The defense, boom, stood up, made an argument, sat back down. That was that. Didn't call any witnesses. A lot of people I've talked to, and myself included, thought the defense didn't call any witnesses. That's strange. You know, why did that's a poor defense? But you say no. No.
In a lot of cases, you don't call witnesses if you're the defense. You got to remember, it's not our job as criminal defense attorneys, which I am, to prove that our client didn't do it. It's the state's job to prove it. So there's a lot of different trains of thoughts from the defense bar. Number one, first and foremost, you get last close, which means you get to tell the jury last your version of events, what you believe happened, and that kind of resonates with them and it sits with them when they first get back there with that first vote. But also, it kind of makes a juror feel like, this trained, great defense attorney that we've been hearing on cross-examination doesn't feel that he even needs to put up a single witness. Am I missing something, or should I be following along with this man? I mean, he's been practicing law for so many years. He's very eloquent in the courtroom. So, there's a lot of different trains of thought. Or sometimes you just don't have any witnesses. Like in this case, Sidney would have been basically the only witness to call, other than maybe Tammy, or if there was some other piece of evidence that we just didn't know about, showing that his phone was somewhere else. But honestly, it didn't surprise me at all, because Sidney did violate the gag order, make statements on the media to the public, which he would have had to stick to if he took the stand. They could have, tried to ruin his credibility and whatnot if he wavered one way or another. So he kind of hamstringed his own lawyer in that. But I think from the get-go, Mr. Truslow wasn't planning on putting up any evidence.
There was much more of a chess game, I assume, going on behind the scenes than the casual observer might realize.
It always is. It always is. I mean, there was multiple hearings behind closed door about the technology, about the expert witnesses, about different witnesses coming in, whether they're relevant or not. I mean, just multiple things that the public did not get to hear about that went on behind the scenes. That played out in court just kind of naturally for everybody to watch. But definitely the video. I mean, the video of the truck is the one I'm talking about. Was it reliable? This is kind of something that we haven't really heard. This is South Carolina. We haven't really heard about this. This isn't the home of the FBI. How can we, explain to a jury out of Horry County what exactly this technology can prove? And boil it down into a concise, clear testimony.
Well, let's talk about that, because I think that was probably one of the key pieces of evidence in this case, was some videotape of a truck that the prosecution tried to tie to Sidney Moore and being at the boat landing in Saucasee, Peachtree boat landing. They took jurors on a field trip, on a bus tour, to see the area that was being talked about. Talk a little bit about this evidence.
Well, first and foremost, it was the evidence. That was it. The truck passing by at that time was the quote-unquote proverbial smoking gun. If you don't have the truck going by, well, they didn't analyze Sidney's phone, so you don't have him at Peachtree Landing. All you have is Sidney saying on a payphone, I called her and told her this was over with, and she went to Peachtree Landing. I believe even the father or somebody said on the news that it was common for her to go to Peachtree Landing. It was common for her to kind of sleep in her car and run away and things like that. So that would have left all sorts of doubt out there. So if you don't have the truck passing by that house at that moment on that isolated, desolate road at 3:45 in the morning, that's a heck of a coincidence. If you don't have that, we don't even make it past directed verdict in this case. But they hinged on that truck because they already had motive. They with the pregnancy test and things like that, they showed it, the cheating spouse, they had motive nailed. Then they just had to have the means and how it got done. And the only way they could do that is to put Sidney in the vicinity of the crime. And the only way to do that was with some technology that I don't even really understand. And I don't know if the jury, if they do come back in fact not guilty, if they do come back hung, they didn't buy the whole truck scenario technology thing. And they probably said, look, it's just not enough for us to be convinced at this moment that that was his truck.
Heather Elvis's car was found at Peachtree Landing in Socastee the morning after she was last seen by her roommate, who recanted her, or not recanted, who talked about what her last conversation was, and that was a powerful piece of witness testimony.
Absolutely.
Let's talk about the witness testimony. There was a lot to sit through from the prosecution standpoint, and you had to hear from the expert witnesses, you had to hear from people like that. But what would you say that she was the key witness?
A lot of people would say that the car was the key witness because they showed it, and I believe the prosecutor actually tried to show it during her closing argument, and the judge kind of struck that down and said, we've already seen it, let's move on. But for me, absolutely, this was an emotional case. That final witness, the roommate, humanized Heather. It brought Heather back into the courtroom. It brought her into the limelight in a way that the jurors kind of got to see that this is a human being. This is a family impacted. This was a young girl. She talked about her dreams, her aspirations. She was going on dates. This was all good for the state. This was the state's best witness, I believe, because it kind of showed she wouldn't be the type to run away. She wouldn't be the type of girl who would just break up a happy home marriage, a home wreck or whatever people were trying to call her, portray her as in the beginning of the trial. But the one thing that she couldn't do is say where Sidney Moore was on that night. So she also kind of hurt the state in the fact that she said she loved him. She was definitely crazy about him, and because that went to Sidney's case where he said, look, I told her to back off. This was over with. I went to a payphone to call her because I didn't want, either I didn't have my phone with me because my wife took it, or I didn't want my wife to see that I was calling her to end things again. So.
Let's take a quick break. When we come back, I want to talk about the possible outcomes here and what it means for the prosecution moving forward.
Absolutely.
All right, we'll be right back with Jonny McCoy. We're discussing the Sidney Moore trial that happened this past week. We'll be right back. Local attorney Jonny McCoy is here. We're talking about the Sidney Moore trial, which happened this past week. Let me throw that disclaimer out. Because of time constraints, we have to tape the show around 3 p.m. on Friday afternoon. Well, just before 3 p.m. on Friday afternoon, the jury came out to say they were deadlocked. The judge said, go back, try to come to a verdict. And that's where we are right now at 3:24 p.m. on Friday afternoon. So let's go from there. What happens if that jury comes back out, just says there's no way we're going to come up with a verdict, we are deadlocked? What's next? Then
the common term mistrial, hung jury, as everybody likes to call it. A hung jury will be announced. Sidney will be released, and the state will have to decide whether or not they want to press charges against him, or actually try him again for the kidnapping, because the charge will still stand. So he will still have to have the kidnapping charge looming over his head, and whether or not the state will want to go forward.
Now, a lot of people are going to say, I don't mean to stop you, but a lot of people, I think I know the answer here, but I haven't always known the answer. Why isn't that double jeopardy?
Well, first and foremost, it's because in a criminal trial, double jeopardy attaches the moment that a jury is sat, okay? But it does not actually come to fruition until a judgment is reached. A proper judgment is reached. That's why it's called a mistrial. Almost like if you somebody stood up in the middle of the court and started screaming things that the judge didn't want you to, say or you couldn't do, then it's a mistrial. You start over. By its very nature, a trial has a beginning and an end. And there's no end, technically, in a mistrial case, in a hung jury case, so the charge is still
So if they come back with a not guilty charge, then state's done. They can't try them again on
just the kidnapping. Now they dropped the murder charge. Well, they dropped the murder charge with leave to restore for this exact reason. If they come back and they find them not guilty of kidnapping, the state, if they find more evidence, if Heather's body appears, if something comes forward, they can try Sidney for murder. So it's not over with by any means if this jury comes back not guilty for Mr. Moore.
If they're deadlocked, do you think the state will try it again?
That comes down to a matter of office policy. So what the state will do is they will find out the best way they can. As criminal defense attorneys, we always try to talk to the jury afterwards. They'll try to find out what, quote, is the count. And a count is basically, where were y'all? How close were y'all to reaching a verdict? Was it 2 holdouts for the state, 2 holdouts for the defense? And if it is 1 or 2 people sitting there saying, I just can't let this guy go, and there's 10 people sitting there saying, this guy, there's just not enough evidence, I don't see how the state could try him again for kidnapping. If 10 people that they hand-selected, or 9 people hand-selected, say that there's just not enough evidence with what you've got, I don't see them retrying him for kidnapping.
Let's talk about the next possible scenario, and that would be not guilty. That would have would that have implications, because Tammy Moore is still facing charges?
Right.
Would that have implications on that, and what do you think that would mean going forward?
Well, we saw with the Baltimore case going on right now, it's just been a domino effect of not guilties in the Freddie Gray case, very tragic case. And what they did in that case was kind of peculiar. They tried one of the least culpable officers first, and the not guilty happened, then they got to the more culpable guys. In this case, they tried Sidney first because they had the most evidence against him. So it would follow that the dominoes would fall. If he's found not guilty of kidnapping, I mean, with the evidence that we just heard, that wasn't Tammy's car. As a matter of fact, Prosecutor Livesay pointed out Tammy never drove the car, ever. She had the young witness testify to that. So I don't see how they could go forward with Tammy on a kidnapping charge at all. But what I do think would happen is that they would try to get her to take, if he was found guilty, they would try to get her to take a lesser included plea, just get this thing over with. But not guilty, Tammy's pretty much off the hook for the kidnapping, and we await more evidence for the murder trial.
Guilty would mean you go ahead with that trial.
Oh, guilty, you go straight into Tammy, you quote unquote threaten her with trial, and hope that she'll take a accessory before, accessory after the fact plea, because there's just not enough evidence to try her on a kidnapping. I mean, we're already at an Allen charge on a case where they had the best evidence against the best defendant. So they would probably reduce the charge down, offer a plea bargain just to put it behind them. And again, the murder charges still linger out there. So if they're in jail, awaiting the murder charges, if new evidence comes up, they try them for it.
Jonny McCoy, thanks for coming in and talking with
Absolutely.
us this morning. Again, we're taping this on a Friday afternoon, so maybe you know more than we do, or maybe we just came over. Maybe we just won over the outcome for you.
Yeah,
so.
we'll see what happens. We'll see what happens. But
right.
but my guess is the people of Horry County, they weighed the evidence closely, and I think that it's probably going to come back as not guilty.